All right. Thank you, Matthew. I hope that everyone here has had a good time in Nashville. And I went to law school about 200 yards from here. And 30 years ago, I was a 3L. And it's very interesting because 30 years ago, no one had any use at all for downtown Nashville. There was nothing there, nothing to do. And it's really extraordinary the last 20 years what has happened to the city, and we hope that you've had a good time. I think if you're from Kansas City, after Sunday afternoon, you may not find Nashville as welcoming as it should have been. Otherwise, I hope everyone has had a good time. It's a pleasure to be here on this panel and moderate it, because we have such a great lineup of speakers. And the topic is an interesting one. On the one hand, very specific, and on the other hand, though, a little bit broad in terms of the concepts reflected: strategic litigation and the power of developing precedent. And there is much to cover within that topic. When I was asked to moderate the panel, I was thinking about what this topic meant to me, and before I introduced our panel, I did want to make just a couple of remarks. One of the things that occurred to me immediately, my time before being a district judge, I did many different things, including, as Matthew mentioned, was Justice Department's legal attaché in Serbia. But I was criminal chief here at the U.S. Attorney's Office. And I would say on the criminal side, criminal litigation, there's no question that we thought in terms of what I would call strategic litigation with an eye towards developing precedent. And there are particular kinds of criminal statutes where this was very much front and center. What strategic fights are you going to pick? What precedent are you seeking to develop or afraid of developing under statutes, for example, under Sarbanes-Oxley, Title 18, United States Code, Section 1519, for example, destruction or alteration or falsification of documents in a federal investigation, or wire fraud gets used all the time, right? But there are strategic and new things that you can do to enforce federal criminal law with that statute. Another example would be using Title 18 United States Code Section 1001 in new ways. And I'm not talking to gin up process crimes. I'm talking about using it to address substantive criminal activity. So we thought strategically about this, and always thought in terms of the precedent that may or may not come out of the Sixth Circuit. Then I thought about its impact really of criminal statutes in the civil litigation I handled after I left the government and was in private practice 8 years before being a district judge. A lot of what I would consider to be my strategic litigation, where precedent was at stake, did involve civil remedies based on criminal statutes. And I'm confident that our panel is going to be focusing on other things. But for me, a big part of private practice, where I represented a lot of really victims of criminal or quasi-criminal activity, but really criminal, would be looking at federal criminal statutes that provided civil remedies. Talking about things like the Racketeer Influenced and Corrupt Organizations Act, which we all know as RICO. I'm talking about Title 18 United States Code Section 1030, fraud in connection with really computers and interstate commerce. Another example would be the federal wiretapping statute. All of these provide civil remedies for aggrieved individuals, in addition to providing the government a prosecutorial remedy. And in using these kinds of statutes, been on the books a while, and have some really sort of well-worn applications. In private practice, I sought to use them in new ways And when deciding whether to use these sorts of statutes in a strategic manner in new ways, one of my criteria really was not to be disingenuous. And one of the checks on being disingenuous in using a statute for strategic purposes in a new way is, my first check on myself was to make sure it's very easy to explain why the conduct that you say entitles your client to a civil remedy does fit easily within at least the words of the statute. Now you can debate what the intent of the statute was and so forth, but make sure it fits easily within the words of the statute. Those were some initial thoughts I had, and my next thoughts were about how great it would be to hear from our panel, because we have really an outstanding panel here, and each of them will be presenting, and then we'll also be taking some questions. And I'm going to introduce our speakers in the order in which they will present. And the first one is Thomas Fisher, who's a Solicitor General of the state of Indiana, the Hoosier State. Tom has served as an Indiana Deputy Attorney General since February 2001 and was named Indiana's first Solicitor General in July of 2005. In that role, he handles high-profile litigation for the state, defends state statutes against constitutional attack, advises the Attorney General on a range of legal and policy issues, and manages the state's U.S. Supreme Court docket. A two-time recipient of the National Association of Attorney General Best Brief Award for Excellence in the U.S. Supreme Court brief writing, Tom has argued 4 times before the High Court. In addition, Tom has argued dozens of important and high-profile cases before both the Indiana Supreme Court and the Seventh Circuit Court of Appeals in Chicago. In 2018, Tom was named a Fellow of the American Academy of Appellate Lawyers. Then we have Dana Berliner, who's Senior Vice President and Litigation Director for the Institute for Justice. Since 2008, Dana has been recognized every year as a best lawyer in eminent domain and condemnation law by the publication Best Lawyers in America. In 2012, Dana became IJ's litigation director. She now oversees all of IJ's litigation, helping other attorneys craft both their major legal theories and their day-to-day litigation strategies. And she helps to set the litigation directions that IJ will take. In 2016, Dana began her role as IJ's Senior Vice President. Dana has been quoted in the New York Times, USA Today, Wall Street Journal, NPR, and the Washington Post, as well as on various radio and television broadcasts, including 60 Minutes. Dana received her law and undergraduate degrees from Yale University, where she was a member of the Yale Law Journal and represented clients through the Legal Services Program. After law school, she clerked for Judge Jerry Smith on the United States Court of Appeals for the Fifth Circuit, and Dana is a member of the DC and Pennsylvania bars. And then we have Jesse Panuccio to bat cleanup. Jesse has experience across a broad range of substantive and regulatory areas. He is currently a partner at Boies, Schiller, and Flexner. And Jesse previously was the acting Associate Attorney General at the U.S. Department of Justice. And in that role, he oversaw the civil and criminal work of the antitrust, civil rights, and environmental and natural resources and tax divisions. In addition, Jesse served as chair of DOJ's Regulatory Reform Task Force and vice chair of DOJ's Task Force on Market Integrity and Consumer Fraud. Jesse served for 3 years as the Secretary of Florida's Labor, Economic Development, and Land Use Agency, which is the Florida Department of Economic Opportunity. Before that, he served as Governor and now Senator Rick Scott's General Counsel. Jesse currently serves as a public member of the Administrative Conference of the United States. He also serves on the Florida Supreme Court Judicial Nominating Commission. Jesse is also a fellow at the Center for the Study of the Administrative State at the Scalia Law School at George Mason University. So what we're going to do, we're going to start with Tom, who's going to have some remarks for him on our topic of strategic litigation and the power of developing precedent. Tom.
Thanks very much, Judge. I'd like to put my remarks on the use of strategic litigation and precedent in the context of what I think is the overall theme of the conference. The idea of expanding, taking an expansive view of tort liability and, in particular, public nuisance. So I'm going to talk a little bit about my kind of basic view of that idea and then bring it back to the idea of how we use strategic litigation and precedent in this area. And I come at it just by way of preface as somebody who I think takes a largely conservative view of the law and a very skeptical view of kind of new and novel uses of traditional remedies. Public nuisance is an unreasonable interference with a right common to the general public. It has traditionally been used to require abatement where private actors spoil the use of real property, such as by using land to interfere with property rights of others, by diverting streams, dumping waste, or blocking public highways or navigable waterways. Over the years, public nuisance claims also grew to impose liability for noxious trades and businesses, such as lotteries, gambling, and adult establishments, all of which were highly localized, specific, and redressable via abatement. Nowadays, however, public nuisance has, as one commentator put it, emerged as a conspicuous weapon in the arsenals of states and municipalities. Public nuisance claims flit from asbestos to tobacco, lead paint to firearms, opioids, climate change. Indeed, employees in at least 9 states have filed lawsuits against businesses claiming that noncompliance with CDC's COVID-19 guidelines constitutes a public nuisance. Recently, a Facebook whistleblower testified before Congress that social media giants should be targeted a la Big Tobacco for creating products that attract and addict youth. Curiously, the profile of public nuisance as a litigation weapon of choice does not stem from widespread courtroom victories. Rather, the sheer size and profile of the Tobacco Master Settlement Agreement, the underlying claims for which were largely, though not exclusively, grounded in public nuisance, indeed in claims that were never fully adjudicated in public nuisance, the Tobacco MSA has inspired countless imitators. Public nuisance has morphed into what some have called a parasitic tort because its amorphous elements make it broadly applicable and subject to manipulation. What is a public right? What is an unreasonable interference? Indeed, what is abatement? The working bet among public nuisance plaintiffs is that modern jurists, having lost touch with our common law traditions, will bend these broad concepts to achieve what, in their view, are socially desirable ends. A decision of the Indiana Supreme Court from nearly 20 years ago gives credence to that theory and illustrates the problem. In City of Gary versus Smith & Wesson from 2003, the court permitted the city to proceed with a public nuisance claim against gun manufacturers to hold them accountable for gun violence perpetrated by street criminals. The city claimed the manufacturers acted unreasonably when they, quote, perpetuated a market for persons proscribed from owning guns. The court erroneously redefined public nuisance as, quote, an activity that, 1, generates injury or inconvenience to others, 2, is both sufficiently grave, and 3, sufficiently foreseeable that it, 4, renders it unreasonable to proceed, at least without compensation, to those that are harmed. Note that the court made no mention of public right, merely injury or inconvenience of others. It also ignored the traditional requirement that a public nuisance defendant must exercise control over the instrumentality of the nuisance at the time of the suit so that abatement is achievable via judicial remedy. Instead, the court found it sufficient that defendants were, quote, on notice of the concentration of illegal handgun sales in a small percentage of dealers, close quote, and that those manufacturers could have refused to sell to those dealers. Now, if the only remedy sought was for the manufacturers to refuse to sell the guns to those dealers in the future, that might have satisfied the control test. But the requested remedy had nothing to do with the future possession of guns, but with paying for past harms that others caused with guns out of the control of the manufacturer. Indeed, the measure of damages urged by the city was as broad as one might imagine: medical costs and lost tax revenue and property values. The court explicitly, the Indiana Supreme Court that is, explicitly held that the city could use public nuisance to, quote, shift the resulting cost from the general public to the party who created it. No positive law, mind you, prohibited the sale of those guns from the manufacturer to the licensed distributor. Leaving aside for this discussion the role and culpability of the distributors, the Indiana Supreme Court's decision leaves us wondering, what is it about the costs inflicted by gun violence, horrific as it is, the gun manufacturers rather than gun offenders must pay? It does not take much imagination to extend similar liability to other manufacturers of legal products, including automobiles and alcohol, that, whether from ordinary use or abuse, yield widespread harm. To use an economic term, all human activity, commercial and otherwise, generates negative externalities. Our legal system has worked out very carefully ways to assign financial responsibility for those negative externalities. We make such default assignments principally through the law of negligence, where responsibility for harm to others is substantially limited by the scope of duty. That is, limits on who may sue whom for what. Absent the proximate relationship that creates a duty of care, compensatory claims for injury arise only as to intentional harms or abnormally dangerous activity, which was not, I hasten to add, the theory of liability in the Gary Gunn case. With respect to the products of industrial output, furthermore, negligence is limited by the law of product liability, which traditionally permits claims for negligent design and manufacture, not for mere negative externality caused by a legal product. For further protection against negative externalities in the modern economy, we of course look to the regulatory state, such as state licensing boards, EPA, FDA, and the entire alphabet soup of administrative agencies. Against this backdrop, the emerging uses of public nuisance to attack all manner of social ills threatens regulatory chaos. It provides a mode of regulation by litigation premised on the judiciary's assessment of whether targeted economic activity is quote-unquote reasonable or quote-unquote sufficiently grave, in the argot of the Indiana Supreme Court, unbounded by meaningful principled limits on appropriate defendants or protectable rights. Modern public nuisance claims frequently convert all manner of serious individual harms into, quote, public rights, including gun crime, poor health, addiction, and the seemingly endless array of injuries assertedly caused by global climate change. Such claims seek not so much abatement tied to property controlled by a defendant as compensation for a wide variety of incidental and consequential damages. In the 1993 case, Tioga Public School District Number 15 versus U.S. Gypsum Company, the Eighth Circuit presciently warned of the devastating potential of public nuisance claims that departed from traditional limits in that way. There, the court rejected a public nuisance claim for asbestos remediation against a manufacturer who lacked control over the product once it was installed. Permitting public nuisance claims to exact liability outside the traditional parameters, the court said would, quote, become a monster that would devour in one gulp the entire law of tort, close quote. To battle that tort-devouring monster, institutional legal actors, including states, should develop and adhere to principles and strategies that limit public nuisance claims to their traditional parameters and respect traditional tort claim limits. In the past decade, Indiana has taken the lead in combating misuse of public nuisance lawsuits in climate change cases. Beginning with American Electric Power versus Connecticut in 2011, Indiana has filed multi-state amicus briefs opposing efforts to use capacious public nuisance theories to extract damages and compel changes to business operations in the name of remedying the effects of global climate change. In AEP, the Supreme Court rejected the use of a federal common law public nuisance theory to target power companies, holding that such claims are displaced by federal statutory and regulatory law, namely the Clean Air Act. The central point of Indiana's amicus brief in AEP was that a court could not, as a matter of institutional competence, balance all competing interests having a stake in greenhouse gas regulation or make a policy decision as to the proper level of CO2 emissions regardless of any initial determination that such emissions constitute a nuisance. In response, the court acknowledged, in response to our argument, that is, the court acknowledged that the judiciary lacks scientific, economic, and technological resources necessary to make these decisions. Furthermore, unlike Congress, the judiciary must rely on a record comprising the evidence the parties present and cannot commission scientific studies or convene groups of experts for advice or issue rules under notice and comment procedures inviting input by any interested person or seek the counsel of regulators. As Justice Ginsburg opined in the case, the court lacked any institutional competence to determine the appropriate amount of regulation of emissions, nor could the court engage in complex balancing a federal agency conducts to weigh energy needs against the impact on the environment with those limits. Still, municipalities and others continue to target fossil fuel producers using nominally state common law public nuisance claims. They seek to hold energy companies liable for the rise in sea levels, an increase in storms, floods, heat waves, drought, extreme precipitation, and other conditions. Such cases, like the failed federal common law claims before them, ask courts to weigh the costs and benefits of fossil fuels and then decide how to regulate them, which are quintessentially legislative judgments. Indiana remains in the fight, urging courts to reject these claims under the central theme that only legislatures, not courts, are equipped to make the trade-offs necessary to address alleged injuries from climate change. Now, what about that Gary Gund case? What is the duty of Indiana public officials concerned about the expansion and misuse of public nuisance, but who think that that case was wrongly decided, but see an opportunity to use it to generate settlement revenues for their governments? It would work great mischief, in my view, to use that case to hold product manufacturers liable for the negative consequences of their legal products. Indeed, the Indiana General Assembly enacted a statute immunizing gun manufacturers from the city of Gary's claims, which reinforces the point that the Indiana Supreme Court took the law of public nuisance in the wrong direction. Common law public nuisance is useful for compelling abatement of specific localized harms, usually tied to the land and redressable via abatement. But it is wholly inapposite for assigning liability for broad social harms, including climate change, which is among the most complex and contentious issues confronting public policymakers today, and which affects, of course, every state and every citizen in the country. Through our strategy opposing public nuisance global climate change lawsuits, our hope is to generate powerful legal precedents that generally cast substantial doubt on new and creative uses of public nuisance claims to remedy broad social ills. Thank you.
Thank you, Tom. Next, we'll hear remarks from Dana.
Hi, so I am not going to talk about public nuisance. I've heard you've heard a lot about it this whole conference, but I'm going to talk about strategic litigation more broadly in the way that we go forward with it. So what we do is strategic litigation, which means we have an idea that we then continue to litigate over time. And I've been there now for virtually 30 years, and I will say that you can expect when you are trying to change the law that it will take decades to do so. Legal change does not happen quickly, and many cases either settle or get mooted or something happens with them. There's legislative change, so that even if you decide you're going to vigorously litigate an issue, it could be 5 years before you even get a merits decision. So having said that, I'm going to talk about one area that we pursue. Novel litigation is often not really novel. It's an idea that has existed, but it's being applied to new factual situations, or sometimes it's not even that the facts are new, it's that the people who are enduring the particular problem have so little financial resources that they never considered challenging what was going on. And so what I'm going to talk about then is financial incentives in adjudication, both on the part of the adjudicator and on the prosecutor. Now, this is not a new theory. There were cases, Toomey versus Ohio and Ward versus City of Monroeville, Toomey said judges cannot have a personal financial interest in the outcome of cases. That's pretty obvious. But Ward versus City of Monroeville expanded that to say that adjudicators could not have an institutional financial interest in the results of the cases. And then in Marshall versus Jericho, the Supreme Court, although it didn't rule in favor of the plaintiff in that case, said that prosecutors too, although they don't have to maintain the same level of neutrality, certainly as judges, still cannot have a significant institutional financial interest in zealous enforcement of the laws. And so we have taken these theories and then begun to apply them. And when you're doing public interest litigation, strategic litigation, you want to start off with a case with very significant and obviously problematic facts. So we brought a case in Philadelphia challenging Philadelphia's forfeiture system. The forfeiture system was, like many in the country, the prosecutors and the police kept essentially everything that was forfeited and could use it at their discretion. That's not all that uncommon, but because this creates problematic financial incentives, they had also developed a courtroom that I still cannot believe that lawyers thought would be okay. They had a courtroom where there was an administrative official, but there wasn't really a judge. The prosecutors sat at both the defendant and plaintiff tables. They did the negotiating, they called the cases, they announced the results. They had people come back repeatedly until they just became so exhausted that they wouldn't fight anymore because they couldn't take off work. There were a host of completely crazy, obviously problematic situations and due process violations. So we challenged that with like so many different claims, one of which was financial incentives. And the case ultimately did resolve through settlement, but we survived a motion to dismiss on that claim. And we survived it based on Marshall versus Jericho, Ward versus City of Monroeville, that significant institutional financial incentives can be a due process problem. So that was really our first case significantly pushing that particular theory. And we then began to apply it to other situations. In Albuquerque, New Mexico, they also had it was a vehicle forfeiture program for DWIs, but they would forfeit the cars whether or not it was the owner who was driving. So in about half the cases, somebody else had borrowed the car, driven it drunk, and then the car was seized. Once again, the unit got to keep all of the money, and as much as it took in was what it could spend. Theoretically, it could have got money from the general budget, but it didn't. It's used the money from the forfeiture program to fund the forfeiture program. And the judge in that case rejected any claim of personal financial interest. It said there was no evidence that the prosecutors were personally going to be influenced. Their salaries did not depend on intake, but there was such a powerful institutional incentive that it violated due process. And that was a 2018 case out of the District of New Mexico. So we then began looking at other situations in which there are prosecutorial programs that are basically self-funded. And there are a lot of them. Another one that existed in California until they changed the statute was very creative, and I find that municipalities in particular can be extremely creative in finding ways to raise revenue through criminal and civil enforcement. So in California, there was a woman named Ramona Morales who was a house cleaner who had purchased a small piece of property that she rented out to tenants. And one of her tenants was keeping an illegal chicken in the backyard. She received a ticket. She told the guy to get rid of his illegal chicken, which he did. And then she went to the hearing. She said, the chicken is gone. They said, well, still, there was a chicken. Let's settle this for $200. And she said, all right, fine, $200 it is. Ticket was done. What they did not mention was that because there had been a successful prosecution for the illegal chicken, she could be charged attorney's fees. So after the time that her ability to appeal the $200 ticket had expired, she received a bill for $2,000 from a private prosecutor who had been delegated the prosecution of all of these property code violations. And when she said, $2,000, I already got rid of the chicken before the hearing, they charged her another $2,000 for the appeal. And this was a situation where a private company had contracted to be the code enforcement prosecutor, and where it then had the ability to secure its attorney's fees. And there are other situations like that in different places. So there are cities, for example, where they get 10 or even 15% of their funding from ticketing, either property code or like speed cameras and stoplights and things like that. There are certainly lots of forfeiture units funded by forfeiture revenues. There are police departments that are very dependent on forfeiture revenues. There are towing companies who get paid for towing. So another case that we recently filed in Wilmington, Delaware. Wilmington, Delaware has contracted with a private towing company, and they don't pay it. So there's no payment for towing the cars. What they do instead is that if the person has not paid off everything within 30 days, the towing company can scrap the car and keep the money. It doesn't go to paying off the debt for the ticket. It just all goes to the towing company, and that's how it gets paid. It does not get compensation from the city. It gets paid by scrapping other people's cars to which it does not have title. And then those tickets remain on the books and people still owe them years later. This, again, we believe creates a problematic institutional incentive on both the part of the city and the towing company, because that's how the company gets paid. So the city's got to allow them to tow cars and scrap them, because otherwise there's no payment and they're not going to have a towing company. So that would be yet another strategic application of essentially the same legal theory. And we're also looking at that in the context of quasi-judicial actions. So for example, we have a case going on in Florida where a guy was getting ticketed for long grass, and the tickets went very, very high because he was out of town and did not realize how high the grass had grown. He'd hired someone to mow it, and then that didn't work out. And there was a hearing, which he couldn't be at. He told them way in advance, and they refused to move it. Now, every lawyer on the face of the earth knows you move your hearing. Like, how many extensions of time have you ever agreed to, right? Hundreds. It's very typical to do that. And if you somehow, a party can't be there, you get yelled at a little bit by the judge. But there's no real consequence. You don't lose the case because you couldn't come to a hearing when you notified the other side you couldn't come. That doesn't happen. But it happened here. The city had a very strong financial incentive because it was going to get to keep the revenues, and so it refused an extension. The guy wasn't there, they fined him, and the fines went up into the tens of thousands of dollars. And this is, again, part of how the city funds itself. Now, we've lost that in the trial court. We're going up. That is very, very typical in strategic litigation. You expect to mostly lose in trial courts, and then to have higher courts consider the legal question more seriously, particularly when you're trying to apply a legal theory to a type of situation that it's never been applied in before. We've also seen other litigators of similar cases. There was one, not ours, out of New Orleans, where the judicial system, the courthouse was partially self-funded through collecting fines after sentencing. And the money was large enough, and the judges had enough discretion over the money that the Fifth Circuit actually found it to be a due process violation, because there was a financial, institutional only, not personal, institutional incentive to convict, because that was how they could get the fines that they then could keep and discretionarily spend as an institution. So this is a theory with many, many applications, and I find every single year some other bizarre system that I would never have thought of that a municipality has come up with that has very significant financial incentives for criminal or civil enforcement. And we then use each of these cases as a building block, applying the theory to different sorts of situations that all share the same legal issue. So sometimes it's forfeiture, sometimes it's quasi-judicial proceedings, sometimes it could even be a judicial proceeding, but all of them revolve around institutional financial incentives and the way that that can distort law enforcement and even potentially judicial priorities. Now, I don't know how much this fits in really to public nuisance. There's certainly an argument for a problem in contingency fees and the way those operate, although that's more of a personal financial incentive issue. And it's also not exactly what we're looking at, because these are incentives to legal, civil, or criminal enforcement, not incentives in a financial lawsuit where you kind of expect there to be some financial incentives. But I think there's at least some overlap and some problems with contingency fees in the context of private people acting as government actors. And I certainly understand the reasons for delegating government functions to private actors, but they create special, very problematic situations that require close judicial oversight because they are so prone to abuse. So I think I've kind of covered how this is just one example. We have all kinds of other legal theories that we're promoting in the same way, but I would expect this one to go forward over the next 10, 20 years as it becomes more widely accepted in courts and as it is seen applying to different situations. Thank you.
All right, thank you, Dana. And finally, we'll hear from Jesse.
Well, thank you, Judge Richardson, and thanks to Tom and Dana for those very insightful remarks, and thanks to the Law and Economics Center for having me here at this very interesting conference or symposium. Our topic is a broad one. It's strategic litigation and the power of developing precedent within the context of novel liability theories and the incentives driving them. So there's a lot of potential ground we could cover, as you've already heard. I'll focus my comments this morning on just a few observations from my time, both as a federal and as a state executive official who was involved in enforcement proceedings and decisions and in developing strategic litigation and making strategic decisions for sometimes novel enforcement liability. So first, let me try to answer the question, why do executive branch agencies and officials pursue novel liability theories through strategic litigation? And I think there are multiple answers to this question. The most charitable explanation is that when executive branch officials confront bad actors and serious and immediate harm, they are in the best position to act swiftly and to ameliorate that harm. That's a pretty bedrock principle of our form of government. You can go back to Hamilton in Federalist 70, where he said energy in the executive is a leading character in the definition of good government. It is essential to the steady administration of the laws, to the protection of property against those irregular and high-handed combinations which sometimes interrupt the ordinary course of justice, to the security of liberty against the enterprises and assaults of ambition, of faction, and of anarchy. So in short, sometimes novel harms require novel strategies, and establishing a new theory of legal liability is part of the good government, as Hamilton called it. Let me provide a recent example of that. You've heard a lot about opioids at this conference, and much debate over whether state attorneys general should be pursuing recoveries under public nuisance theories. What you've probably not heard much about are the first of their kind injunctive relief cases that DOJ brought under the Controlled Substances Act in 2018 to shut down doctors and pharmacies who were misprescribing opioids. And the evidence here was overwhelming. There was statistical evidence, there was undercover evidence of doctors essentially acting as drug dealers with opioids. Those suits were novel. That injunctive provision of the CSA had never really been used before. But DOJ had also never confronted a drug crisis in which the dealers were acting under the cover of DEA licenses. And so I can tell you that as a matter of strategy, we thought long and hard about which of those cases to bring first. We wanted rock-solid cases so that the initial salvos would be court victories that we could then build upon to put drug dealers out of business across the country. Now, beyond the good intentions to abate immediate harm, there can also be less charitable explanations for executive actors to set novel liability precedents. You've heard Dana discuss her view that financial incentives often drive enforcement. That can be true for local municipalities and police departments writing traffic tickets or engaged in forfeiture, but it can also be true in much more substantial or wide-ranging contexts. For example, there is a little-known funding mechanism at the U.S. Department of Justice called the 3% Fund, under which DOJ can keep and use 3% of all civil fines that it collects. DOJ collects billions in such fines each year, such that the 3% Fund can become the pillar upon which jobs and programs rely at the department. Indeed, just taking one period from about 2008 to 2016, DOJ collected $66 billion in civil fines, meaning that it had about $2 billion, that's billion with a B, $2 billion to allocate to priorities of its own choosing without direction or interference or approval from Congress. The potential incentive to drift toward novel liability theories to expand recoveries is thus obvious, especially because many theories never actually get tested in litigation that goes to judgment. Most parties facing massive potential federal liability opt to settle. And this is an important point to understand about how enforcing agencies build what we would call precedent. It often need not be liability theories that have been approved through testing and litigation and judicial opinions. It can simply be something that is set down in a settlement, and then later enforcers can come and say, well, we've done this before, and parties always settle, and therefore we have authority to do it, even though no judge, no court has ever signed off on that legal theory or that power. So that all sounds pretty bad when I put it that way, but there's always another side to the story. I mean, this is a law and economics conference, and don't we usually like to see some connection between performance and budget? After all, decoupling enforcement from the dollars that enforcers collect can lead to under-enforcement. I saw this up close when I was a state labor secretary. Unemployment insurance funds flow to and from a federal trust fund, so very few state prosecutors were interested in pursuing unemployment fraud, even in the face of overwhelming evidence and even though it occurred in a state-run program. It wasn't the state's money, the recoveries didn't go to the state coffers, and so no one really cared, to be honest. And federal enforcement was meager because unemployment fraud, which costs hundreds of billions of dollars to the trust fund every year, was left mostly to thinly staffed and poorly funded Department of Labor IG officials. There was no connection between the work they were doing and the funding they received. And therefore, there is still to this day massive under-enforcement of unemployment fraud. So I guess I'd say the funding rationale for novel enforcement theories, or enforcement generally, is a complicated one, but it surely plays some part in motivating executive branch actors to pursue new liability theories. Another motivation for enforcement, and in my experience one far more powerful and malignant than financial incentives, is politics and publicity. When elected and appointed officials feel pressure to react to a crisis, either from the media or from interest groups that they care about, they often search for some way, any way, to say they are doing something. And sometimes a novel, or even half-baked, or ill-advised, or malicious enforcement threat or liability theory is the response. Perhaps that is why Attorney General Garland recently threatened prosecution for parents who speak out at school board meetings. There's no good explanation for his unprecedented memo, other than an interest group asked him to issue it. And it matches the politics of the moment for the constituencies he and his team care about. And on that front, it's worth noting again, as with out-of-court settlements, an entity as powerful as DOJ need not necessarily establish liability precedent in court. It need not actually win in court to change behavior. Sometimes the enforcement threat alone is enough, especially when you are dealing with parties without the resources or wherewithal to fight back, as Dana mentioned in her comments. Finally, on this topic of how and why executive agencies might seek to establish and build upon novel liability theories, I think there's an important structural point to be made. One argument I heard a panelist make yesterday is that a new theory of liability, if a new theory of liability is needed to meet a new societal harm, the legislative branch should be the one to establish it. Now, maybe that was true 150 years ago, but Congress long ago ceded nearly all of its power to the executive branch, permitting agencies to legislate, enforce, and even adjudicate the rules by which we now live. And when our enfeebled and atrophied Congress does deign to pass statutes creating new fonts of liability, it often leaves the details vague, perfectly content to take the political credit for addressing a problem while avoiding the political accountability of hashing out the controversial details. Thus, is it any wonder that federal executive agencies view novel litigation strategies as simply another instrumentality of their now all-encompassing regulatory power? And as an aside, or maybe a footnote to that, I think this structural problem is far less prevalent at the state level. State legislatures, in my experience, are much more careful in controlling executive agencies and are very active in creating new fonts of statutory liability to address new harms and controversies. And when state legislatures pass these statutes, it often takes years of iterative litigation to flesh out interpretive questions. We are seeing that now, for example, with privacy lawsuits against big tech companies. Those cases include some common law causes of action, but they also include causes of action under statutes like the CCPA. So when we think about novel liability theories and building precedent, it is useful to think beyond the common law debate and also account for state legislative action. With that, let me move to my second point about the power of developing precedent. Namely, that once an executive agency has established a liability-imposing precedent, it never retreats, never. The incentive is always to exercise, defend, and expand the power. Some cases and issues from the Trump administration are good examples. Let me provide three of them briefly. Let's take Auer deference, for example. For those who don't recall this from law school or aren't familiar with it, under this doctrine, federal courts will defer to federal agency interpretations of the agency's own regulations. In other words, this precedent provides the executive branch with the power to impose liability through what's known as sub-regulatory guidance. This is deeply problematic from a rule of law perspective because such guidance is not passed by Congress and does not even go through the formal APA rulemaking process. The agency just announces it in a guidance document or sometimes a blog post or sometimes for the first time in litigation in a legal brief. And then parties are bound by it because courts defer to it. So to curb this problematic practice, both President Trump and AG Sessions all but outlawed reliance on sub-regulatory guidance through executive orders and policy memoranda. Yet when the Department of Justice had the chance to urge the Supreme Court to overrule our once and for all, it blinked. The Office of the Solicitor General chose to defend the precedent, and the Supreme Court preserved the doctrine in the Kaiser versus Wilkie case. Now, there was no way to square the policy announcements of DOJ prior to the Kaiser case with the legal position it ultimately took. But at the end of the day, the executive branch simply could not bring itself to forego a hard-won, liability-imposing precedent. Let's take another example, the issue of third-party payments in DOJ settlement agreements. For those who haven't heard about these, when DOJ brings a civil or criminal enforcement case, parties often settle, as I mentioned, reasoning that they can get a much better deal than the potential liability they're facing. DOJ, since about the 1980s, and with increasing frequency since then, has used these settlements to require not just fines to be deposited into the federal fisc, but also payments to be made to third parties, such as nonprofit organizations politically aligned with the administration then in power. For example, during the Obama administration, DOJ required big banks seeking to settle the residential mortgage-backed security cases to pay billions of dollars in third-party payments to organizations closely tied to the administration's policy agenda. Many commentators noted that such payments raise serious constitutional and ethical concerns. Thus, both AG Sessions and AG Barr put in place policies prohibiting such third-party payment provisions in DOJ settlements. But these policies, when they were put in place, were fought tooth and nail by many DOJ and other executive officials, both political and career, who had come to rely on such payments as an enforcement tool in their daily jobs. Thus, it is no surprise that one of AG Garland's first actions after taking office was to rescind these prohibitions. Again, executive branch officials do not soon part with liability-imposing tools once they have them. And the same is true for a third and final example, consent decrees. Consent decrees resolving allegations of federal liability give DOJ tremendous power to dictate the policy and spending priorities of state and local governments who are accused of violating federal law. These decrees have grown in prominence since the 1970s, and like third-party payments and settlements, reached a crescendo during the Obama years. So again, after there was much concern about the ethics and legality of these decrees, AG Sessions put in place a policy to seriously curb their use and make sure they were appropriately limited. Again, over the vehement objections from some career and political officials alike within the Department of Justice. And again, one of the new administration's first actions upon taking office was to rescind this policy. Consent decrees with state and local governments are simply too attractive a means of establishing all manner of liability and remedies, including those that could never be won in litigation to judgment. Again, we see this phenomenon of DOJ setting an enforcement precedent and having an enforcement authority that they actually don't have to take to a judgment because they get parties to settle to it, and then it expands and expands and expands as consent decrees have over the years. So I could go on about the details here, but the takeaway is this. Internal forces within the executive branch almost never want to give up liability-imposing power once granted. So as I think Tom said, or at least implied in his comments, executive officials who care about the limits of power should be very careful in adopting new theories of liability, because once established, they are permanent and they metastasize. Thanks very much. I look forward to questions.
All right. Thank you, Jesse. I have a million thoughts and questions myself, but I will refrain from getting into that and instead proceed directly to questions I've received on the tablet here from attendees here, and they're good ones, so we'll get right to it. One question, and I'm going to get to as many as I can, and if I don't get to yours, please don't take it personally. Here's one, and it's an excellent one, and it occurs to me naturally as a Nashvilleian because private prison industry has a presence in Nashville in multiple ways. Does IJ have the same concern with private prisons? There's a lot of questions about the incentives, perverse or otherwise, that are created by a private prison regime. What are your thoughts, Dana?
Well, so I haven't looked deeply into private prisons. There has been some litigation in that context, not by us. I know that because private prisons are taking over a role as a state actor, they are subject to the Constitution, just as a public prison is, which means they have to abide by due process, equal protection, freedom of religion. All of that applies within a private prison. And it's always a problem when you have private people acting with government power. I don't know about particular policies within prisons, but I can certainly say that there's a high risk in that situation because you have a profit-making entity with very high degrees of power, and although there are constraints, as we all know, those constraints are lower in prisons. And there's a reason for that, and that's understandable, but then the need to have that extreme level of power not abused is important, and it's harder to monitor. And actually, one thing that some courts have suggested is that basically you look closer at due process problems when there are financial incentives involved. And this would certainly be a situation where that would be appropriate to do, where perhaps the deference that might be given in a public prison setting would not be merited in the same way in a private for-profit prison.
All right, thank you, Dana. And one question that I wanted to ask, and that was asked here, and we could have multiple different views on this, and I'm going to throw it out there and see who wants to take it first. So what do you think about AG offices funding their offices with attorney's fees for multi-state litigation? I'm tempted to direct it to Tom as with an AG office, but that may not be fair. Anyone want to take that one?
Well, yeah, what the heck?
Yeah.
So, right, I mean, I think the general concern there is, are we getting close to some kind of separation of powers line with respect to fees that are paid through litigation and not specifically appropriated by the General Assembly? And I think it's definitely a legitimate concern. I think, you've got to pay attention to the authority bestowed by a legislature on an AG office in that context. And, different state constitutions may have different things to say about that, but I think authority for a General Assembly to intercede if things aren't going, according to what they think the proper policy ought to be, generally is there, even if you have a constitutional AG office. I think there'd be some substantial authority for the General Assembly to be able to intercede. But I generally think that it is worth being concerned about that issue and paying close attention to where the legislative lines are drawn.
All right. Thank you, Tom. I'm going to ask this question, and there's probably some interpretation as to what is being asked here. So if someone wants to take this one. Panelists suggested that there are unintended preferential consequences to some litigation decisions. Please say more on that and whether it matters more to repeat players. I guess repeat litigants. Panelists suggested that there are unintended preferential consequences to some litigation decisions. Say more on that and whether it matters more to repeat players. one of the things, and the notion there to me, unintended consequences to some litigation decisions, I think is important. I wasn't sure what the questioner had in mind about referring to preferential consequences. Anyone think they have a response to that one?
Well, I give some interpretation of the question here, but I think, playing off a theme that both Dana and I mentioned, is that if you're at least looking at strategic litigation from the government side in the building of precedent, the motivation for the government to litigate or otherwise pursue novel liability theories is high because they are repeat players in the system. And so if they gain a new font of liability imposing power, now they have a new tool in their toolbox. But the targets of that are one-off players. And so as I think I mentioned, the motivation is usually to just get out from under it. And so there's very few players in the system who are the target of that enforcement effort that want to take the time or expense to litigate it or stand up and say, well, there's something structurally wrong here. This isn't just about me. We're creating a whole structure that's unconstitutional or ethically problematic. So I think that's a real issue in the system, and it's not unique to this. I mean, it's prosecution generally faces that issue. It's why we have 90-something% of cases get pled, but it's an issue, and it certainly results in a one-way ratchet for the government.
All right, thank you, Jesse.
Yep,
you may.
Yeah, great. No, I think Jesse's answer is really terrific, and it starts me thinking about the ways that our concern about public nuisance claims does prompt, I think, or ought to prompt consideration for other areas where states are vulnerable potentially. So in going back to the climate change context, one of the arguments that we've been making about some of the broad climate change public nuisance claims is that they threaten. It's not simply about broadening the nature of public nuisance, but about broadening the scope of state authority from one state to another. And the idea here that the climate change cases demand a type of relief that essentially expands state and local regulation extraterritorially. So you end up with the potential for using a public nuisance claim to reach beyond a state's borders. Now, at the same time, there are a lot of state interests in resisting extraterritorial regulation from other states, right? Because we all have the need to protect our own state prerogatives at our borders. And so I think it warrants that kind of thinking about unintended consequences when you're considering the reach of public nuisance claims, and to think about the implications of that for your position on something like extraterritoriality. So I think that that's one of the challenges of expanding claims into novel areas is how are you going to potentially step on your own tail in some other context.
All right, thanks, Tom. Another interesting question about potential consequences and incentives to maybe, in fact, avoid them. Question, what about the risk of a new theory creating precedent being a reason to avoid creating it by settling? And I think I know what the questioner is asking. I can think of situations in front of me where it's pretty clear to me from where I sat that a response to an interlocutory decision that I issued was to settle, and rather than risk bad precedent in the Sixth Circuit if I was affirmed. Whether it, if the party wants to take it up, that's great. Sixth Circuit decides. But the question being, sometimes is there really a fear that you're not going to get the result you want, and there'll be precedent that will hurt you in the future as a potential repeat player, and so you avoid that risk of bad precedent by settling. I'm going to ask our panelists this, but I would note that maybe the party asserting the theory needs to have the courage of its convictions. Say, you know what, this is a good theory. We're going to litigate it. We got to have the courage of our conviction. If we get a bad result, bad precedent, so be it. But we think we should get a good result, and that this should be the precedent, should be in our favor. However, risk-averse parties who are repeat players might want to settle in order to avoid creating negative precedent. All right, what do folks think about that?
Well, we see this all the time, where we bring a case, and if the facts are bad enough, the government will immediately settle, or at least attempt to do so. We're almost never suing for money, so it's all a question of injunctive relief. But I would say more often than not, as soon as we bring a forfeiture lawsuit, the money is returned virtually instantly in an attempt to moot the case. We have dealt with this by bringing class action lawsuits because we want to have the courage of our convictions. We want to get a legal ruling, and it can be difficult to do that if you bring it just on behalf of one person who's got their money back. We had a case where a guy was pulled over. He had cash, and he had all of this evidence that it was a Christian Thai rock band raising money for an orphanage. And like there were little envelopes like for the such and such orphanage, for this school. And they attempted to forfeit the money. And like the second we filed that, they were returning it because there was no way that was going to survive. So we definitely see government entities trying to avoid injunctions by backing off of particular enforcement actions. Sometimes in municipalities we see legal change, and sometimes there's even state legal change. I mentioned the case of the woman with the tenant with the illegal chicken. In the middle of that lawsuit, not, I think, just because of our lawsuit, but because of other things like that, they forbade that kind of private prosecutorial collections, and the California legislature did. I think state level change happens less because it just can't happen nearly as fast as municipal change. But it is certainly true that many litigants will attempt to avoid injunctive relief and avoid a decision.
And I can add to that, I guess, from the two different legal careers I've had as a state lawyer, counsel to a governor. I certainly advised and adopted what I would call case mooting evasive action. That could be settlement. It could be taking action that just mooted gave relief, and as Dana said, then mooted the case because we were worried about where that precedent would lead. Sometimes you make that decision just based on the merits of the case. Sometimes, frankly, you make it based on the court you're in and whether you think it is more favorable to be in a different forum later to fight this battle. And similarly, in my career as a private attorney counseling major corporations who are repeat players, it is often the case where settling, depending on jurisdiction, potential liability, in other cases, settling or otherwise mooting the case makes a lot of sense. So that absolutely is sort of I guess what you'd call the other side of strategic litigation for precedent setting, which is avoiding it as best you can when you're on the defense side.
I think that as states, we have to worry about something that it's not as important for, candidly, municipalities, and especially not as important for private industry, which is if you've gotten to a point in a case where you've got, whether it's an interlocutory order or a final judgment or something, some ruling, and the consideration is whether to appeal that, you need to be thinking about collateral estoppel, right? You need to be thinking about, if you don't pursue the appeal, are you going to be stopped from litigating this issue down the road? It's not always an easy answer to figure out, and it's not always the same answer from case to case, depending on the equities. But as a state, as a large institutional actor with unique interests, you have to be very concerned about that, because maybe there's nobody else to litigate that issue in the future if you settle it now. Maybe it's just, you're going to be stuck with it forever. So, is it worth it? I think municipalities, there's a lot of municipalities, there's a lot of private industries that even if you want to settle out in one case and you're particular client is stopped in the future, you may not care because there are going to be plenty of opportunities for others to litigate the issue. But it's a different calculus to some extent for states.
All right, we got about 3 minutes, and I think I have 3 questions, so we'll try and get a series of 1-minute answers. One is for Jesse. This may be a reference, if I heard Jesse correctly, do the reference of DOJ being able to use 3% of fines. But the way the question's written is, did DOJ drop the policy of using 5% of awards after 2016?
No. No.
No.
I mean, it's a law. I mean, it is a statute that Congress passed that said there is a 3% fund, and DOJ can keep 3% of the civil fines collected and then use it for Department of Priorities. So I'm not sure that, then you get a question of whether it would be illegal for DOJ not to do that. But the answer is no. And there is a committee inside. It's called the CRAB. I forget what CRAB stands for. But it's a committee of department officials who meet, and then all the department programs make proposals for that 3%, and then the money is doled out. So, there are some controls around it, and in my experience, it wasn't used for any nefarious purposes. But that incentive is there, and the fund exists to this day, as far as I know.
All right, one for Tom. Does the novel theory of nuisance used by private firms representing municipal government set a precedent to replace the role of AGs?
Nothing replaces the role of AGs. Well, and I think this goes back to the overall concern about when public litigation becomes something where the municipalities see a need to have their piece of the pie. We are talking in general about, in these types of cases, about a form of regulation. And this is the concerning thing about expanding public nuisance into these areas of social policy, which is why are we going to permit potentially municipalities to be creating that public policy when they're not designed, they're not set up for that, they're not generally given that authority, and yet they're going to have that kind of, potentially that kind of impact. So I liked my regulation the old-fashioned way, through democracy, and I think if we're going to have broad public nuisance claims, probably the worst place to do it is the municipal level.
All right, we have time for one more, and it looks like there are a few I didn't get to, and apologies for that. Perhaps you can catch up with our panelists on break. But one more, and this will be for Dana. Do you agree that private attorneys have more resources and incentives than attorneys general to vigorously prosecute public nuisance claims? What do you think?
Public nuisance claims. I mean, again, we don't litigate public nuisance claims, so I know less about that. It's not really been my experience in the kind of injunctive cases that we do that private attorneys have more resources. Sometimes cities in particular will contract out their defense of the cases, or they'll have a private city attorney. And I mean, honestly, they tend to run up the bills more, but I don't know that they've got more resources than the city does, and the city would end up paying for it anyway.
One of the things, and one of the reasons I directed at you was there could be a twist on that saying, what about organizations like IJ? Do they have the ability to do things? Do you feel, can you feel that they're, the way they are resourced gives them abilities that maybe attorney generals just can't handle?
Well, we have focus. I mean, attorney generals have to cover so many different issues, and a public interest law firm can select 4, 5 issues that they want to pursue for decades on end. It's just you've thought so much more about those particular things. So I'm not sure it's a question of resources in a financial sense as much as it is focus.
All right, very well. I really appreciate our panelists and their remarks today, which to me were very edifying. And I wanted to say this. If anyone has not made it down to Broadway, I recommend you go, but keep out of the way of those big, bachelorette party vehicles. They can be very dangerous. But if you can make it down there, it's recommended. They are a public nuisance. Thanks.